So welcome to another video where I'm going over the different parts of the bankruptcy petition. Now I'm going through the exact order that it's available on the court's website, and you'll have that link in the description. So it might seem a little out of place, but just to avoid confusion, I just go straight down the line. Now, here as you can see, I'm dealing with secured creditors. Now, one of the first things I want you to understand is when it comes to whatever assets you have, and we're talking secure, we're typically talking a mortgage or car payments, you have to list all your assets. So I know a lot of times people think, well, I'm keeping my car, so I'm not going to put that into bankruptcy. That word put into the bankruptcy is deceiving because it doesn't mean you're giving up that asset. You're listing that asset. Now, whether you get to keep it or not depends on the exemptions. Now, I am going through each state specifically with statutes, completely updated, etc., for the exemptions. You can definitely check out my blog, bankruptcy.blog, to see your states there. I'm currently going through all the courts, all the trustees, and then I'm doing the exemptions. I've done maybe half the states so far. So it's a little time consuming, so I apologize for that. But I'm being specific because if there's one thing I realize is a lot of the information out there is extremely outdated. So I'm just trying to make sure that I can provide statutes and everything else so everybody can look it up. Now, one of the first things I want you to see, and I've written blogs about this before. I actually posted it the other day. That is a horrible X. So let's try it one more time. There we go. One of the things that I posted the other day on social media was the issue of what happens if you forgot a creditor. And whatever I say, you could always try going on my website. Just do a search. There's a search engine there that you'll be able to find what you're looking for. But what happens if you forgot a creditor? So if that's the case, remember you have to mark that off and check it that this is an amended petition. Everybody has to get notice again, etc. Now, when we're talking secured debts, it's very brief. I'm always focused on what are the issues that I see versus explaining how to do this because a lot of this is self-explanatory, right? Like who is the creditor, what address are they in, etc. Let me start off over here when it comes to the actual home. Now, let's just put hypothetically your home is worth $100,000 and you have a $25,000 mortgage. If that's the case, then obviously you have $75,000 in equity. Now, is that an issue? Yes or no? Well, it really depends. In Florida, the exemptions are unlimited exemptions, while you just move up to the neighbor, to my northerly neighbor in Georgia. Even if you live 5 minutes into Georgia, once you're there, you have to apply the state exemptions of Georgia, which are only $21,500. So you can see anything above that amount wouldn't be protected. So that's when you have to start thinking about if you're going to have to file Chapter 13. Is it worth it or not? But you can see the difference. Florida, that $75,000 in equity would be protected. It wouldn't be an issue. But now you go to Georgia and you have a problem of what, $53,500. That part is not exempt. And so that's why when you look at, and I've posted this on my blog, when you look at how many Chapter 7s are filed in Florida, as expected, a lot more. Why? Just because the protections are so much higher. Then you just go to Georgia and all of a sudden Chapter 13s are through the roof because if you own a home, only $21,500 is protected. But that's the important part there. Now, what happens with this? First, typically you sign a reaffirmation agreement, and I've written about that and I've done videos as well. The reaffirmation agreement is just an agreement stating you're going to keep that asset. Now, there is a catch with reaffirmation agreements, and I've talked about that before, where understand that the biggest problem is when you file for Chapter 7 bankruptcy, you can't file again for another 8 years. Now, what happens if things change during that time? Well, bankruptcy is always about getting rid of debt, right? But now when you sign a reaffirmation agreement, you're saying, I'm keeping that debt and I'm keeping it out of the bankruptcy because I'm going to keep that car, I'm going to keep my house. If you lose your job, if you have a shortage of income, anything like that, and this falls within the 8-year period, guess what? The creditor is going to take the repossession and then sue you on the balance of what's pending on your car loan or your mortgage. So now the lender is going to move forward with the lawsuit and do a wage garnishment, and they have all this time frame to collect until you do the second bankruptcy 8 years later. So reaffirmation agreements, They're tricky, but here's the catch. You have to find out whether you live in what we call a ride-through state. Florida is definitely one of them, where sometimes you won't sign off either on the mortgage or the car note. And so it's just kind of in limbo. It's just sitting there, but every time you send out the check to the creditor, they cash it. And then when you pay off your mortgage, they put a satisfaction of mortgage with the county records. And if you paid off your car, they send you, the title. But that's Florida. Every state is different. And so the problem, what the one issue with that is if you don't sign a reaffirmation agreement, and this is 100% live from creditors, they state that they cannot report that on your credit report because that's violating the Fair Debt Collection Practices Act. Now, let's be clear. That's totally made up law. There's no such thing. That's just creditors pushing you to sign, for your car note or whatever to keep this secured asset. In case you default, they can come after you later. Now, when it's not reported to the credit bureau, guess what? You've been making mortgage payments for 10 years. You want to now refinance your mortgage, and your mortgage company says, this isn't on, or the new mortgage company, this isn't on your credit report. So you haven't gotten any credit. Now think about that. You've been making payments for 10 years and you get zero credit for that. That's the problem when you don't sign a reaffirmation agreement. So just keep that in mind. You just can't, tell creditors, I'm not going to sign anything just in case it hits the fan. But the answer is then, or the response is, they're probably not going to list it on the credit report with this made up rule that they have that it violates the Fair Debt Collection Practices Act. You could always argue with them. Will it get you nowhere? I've never seen anybody successfully convince these mortgage companies or car loans to change that and update the credit report. So keep that in mind when it comes to the reaffirmation agreement. All right. Now, this is with a mortgage. No different if we're doing this with issues with, if it's a car, if it's a car loan, you can just put there, mark this off here and that's good enough. But here's another thing that I do want you to consider, and that's right here. One of the other issues that I see comes when there's a divorce. And sometimes people are concerned and say, well, we're going through divorce. Neither one of us can keep the house. We're going to I need to file for bankruptcy immediately. Whoa, whoa, whoa. Slow down. Go talk to your lawyer, your divorce lawyer, and go talk to a bankruptcy lawyer at that point. Because here's the problem. What if you sell the home and at the end of the day, and let's just go back to this example. Now, this doesn't matter whether you live in Florida or not, and you're splitting up this amount here between the two of you, right? What happens with those funds? Realistically, those funds have to be invested into a new home in order to protect that. If the money's just sitting in the bank account, then it's not protected. It's the same thing that I've told clients with your IRA and your 401k. Those pension accounts, they're protected. But once you transfer the money from here to a regular checking account, you lose that protection. So it's protected 5 seconds ago. It's not once you do that change. And so that's the problem that you also have to realize, that if you're in a divorce situation, what is going to happen ultimately? A lot of times I just tell clients, maybe you guys don't get along, but it's time you file a bankruptcy together, get this out of the way, get those debts out of the way, and then file for divorce in a few months, then sell the house, and by then you'll be okay. Now, realistically, and a lot of states have this, that if you have the money from the sale of a home, you can then, you have up to like a 2-year time period to roll it over into a new home. But I just think you're asking for trouble. That trustee is going to be sitting around making sure that in those 2 years, and trust me, they will check to see if a home was bought in the 2-year time period or whatever time period is offered by your state. Now, the other thing with dealing with these divorce issues is understand that that's really important if you live somewhere, let's say like in Miami. So here, what do we have? We have 37. Let me write this up again. We have 37.5, right? Each of you are taking. $37,500 doesn't get you a deposit on a home in Miami. So if you're living in a town with, the cost of living is very high, you're going to have this problem of what to do with the funds. So keep that in mind, because again, if the funds are just sitting in a bank account, you could have problems with the trustee. And at the same time, those funds are not enough to deposit into a new home. So what are you going to do at that point? Whether it's negotiate with the creditors, try to pay off that debt, that might be an option that you'll have to consider. Okay. But definitely when you're facing a divorce, find out what your house is worth. What is the equity? What's the magical number of equity? And is that equity protected in your state or not? If it's not protected, now you know. You're going to have to make some decisions and figure out, you're going to have to get together with your partner, even though you're going through divorce, and say, let's file for bankruptcy together, wipe out all this debt. And as a matter of fact, that's actually a good thing, because what happens is a lot of time divorces don't go through because there is so much debt and everyone's trying to make the other side pay. Well, if you do bankruptcy, then you can, wipe out that debt and now start fresh with a brand new home with a deposit. And again, depends on the area that you live in or town, because that's not going to be enough to buy anything in Miami, but in other states, that's more than enough. So keep that in mind. All right, so quick video here then on what the secured assets are. This part here, remember that the exemptions are Schedule C, which I went over in a prior video. So make sure to go back there and look at how Schedule C, how to apply the exemptions, and also Schedule AB, which is a summary of all your assets and liabilities. And the interesting thing about Schedule AB is that it gives you a breakdown, a summary of what your assets and liabilities are, and that's a good way to catch your errors. If there's one thing that I've been saying throughout these videos, is that make sure to review everything multiple times, especially if you're following the blog. I've said 1,000 times over that a lot of the exemption amounts are wrong, even with the state. Definitely some of the more popular sites that just focus on federal exemptions. All mine are up to date. I use software that makes sure that's up to date. I use Westlaw, which is a paid service for lawyers. So I know I'm up to date. But if you're applying the exemptions and you live one of these states where maybe the 75,000 is a problem, make sure you know what the exemptions are, because remember, once you file Chapter 7 and you have assets that are not protected, that trustee isn't going nowhere. Filing a dismissal, they're going to object. If you don't appear to court to try to get it dismissed, they're not going to do that either. They're going to fight you tooth and nail. And why? Well, the simple and short answer is money. This is where the trustees make their money, on assets that are not secured. It just depends on the amount. Obviously the higher amount you go, but at the minimum, they're looking at 25% of that amount. So all of a sudden, what you owe them in a hurry starts to add up. And now you see why they're not going to let go if all of a sudden you filed incorrectly your bankruptcy petition. My suggestion, if there's assets involved, at least have a lawyer look for it. Most lawyers will offer a flexible payment plan. If you still can't afford it, or in your area there doesn't happen to be a lawyer that's flexible, then at least pay a lawyer just to review it. I've seen people make a lot of mistakes when they have their home. It wasn't too long ago that I spoke with a client who didn't realize he made a mistake with his home, and now the trustee was going after his home. And there's really not much you can do, because even if you try to convert it to a Chapter 13, which you might have a sympathetic judge that says okay, but a Chapter 13 is literally taking money out of the pocket of the Chapter 7 trustee. So trust me, the Chapter 7 trustee is going to object, even if you say, well, I'll file a Chapter 13. Okay? Any questions or comments, feel free to post them in the comment section below. Remember, go through my blog if you're looking up for any information, or even the YouTube channels if you're looking for information, say like the 341 meeting of creditors. I've done multiple blogs and videos on that. Okay? Take care, everybody, and best of luck with your bankruptcy case.